Morning, members. We're just waiting for the chair to log on.
Good morning, honorable members. I'm still waiting. We don't make a quorum according to the numbers. Am I correct, Ari or Ayan?
We are 5 members, Chair, so we can continue. But in order to make decisions, we need to be 6. But for now,
Okay.
we're 5, yes, Chair.
Okay, with that guidance, my apologies, honorable members. I forgot my iPad KZN, so I'm using the smartphone for the proceedings of today. I lost my laptop. They're still tracing it. Without any delays, I'm not sure. I needed to check with if we had someone from legal services, so that before we.
Parliament Legal Service, Chair.
Yes.
Yes, we do, Chair. Ma'am Tati.
Oh, okay.
And we are 6 now, Chair. Ma'am Kwebani just joined us now as well.
Okay. Welcome, Honorable Kwebane, to the PC on Mineral Resources and Energy. You are quite welcome. I'm sure it's your first attendance today.
Thank you, Chairperson, for welcoming me. Indeed, I am joining for the first time for the deliberations. I once joined for the preparations. We were going for the hearings. Yes, I'll stand in for my colleague, Mr. Xesa. Thank you.
Okay, thank you very much. Now, maybe let's start with the normal things. Ari, my apologies for that. Then take apologies. Are there any apologies?
Yes, Chair. Mr. Lorimer, who's unable to attend as he's traveling at the moment. And then, as Ma'am Kwebane indicated, Mr. Xesa, who's unable to attend. And then we've also received an apology from the Minister of Mineral Resources and Energy, Chair. He's attending a prior commitment in the Northwest Province, Chair. So those are the apologies, Chair.
Okay. The reason I was asking, Ari, is something that probably might be raised at the committee. It's better to deal with it prior we do with the deliberations. And my also apologies that it is not on the agenda. We have 3 areas that we have not made a decision. Maybe also, Ari, you may come in. There are 3 areas that we have not, we could not have the hearing. And those 3, we all know, Sirast, Bethlehem, and Velkom. I was just thinking maybe the committee can assist that in that process, when we invite the department to make presentations and responses on the submissions that have been made so far, will that not be interpreted in terms of the rules of fairness and procedure, interpreted to be treating unfairly those 3 if we so decide? Or shouldn't we first decide whether we will reconvene those 3 and then decide then what becomes the status of their submission if they so do so? That's why I was asking Parliamentary Legal Services whether they can help us. If we conclude later on to revisit those areas, reconvene, will it not be interpreted to be just doing it for the sake of compliance in prejudice? Will we still re-invite the department to respond to those new or those provincial public hearing submissions? I'm not sure we can, Ari and Parliamentary Legal Services maybe come first, and then we hear from honorable members. I'm sorry, the department, welcome. I saw the department is also here. I hope I was seeing well that the DG is also here in the meeting. Ari and Jenkins.
No. Advocate Mtati, Chair.
Okay.
Yeah. No, Chair, the remaining or the outstanding provincial public hearings, the 2 in the Free State and the 1 in the Northwest. Remember, we compiling a consolidated report on the provincial public hearings on the ERA. So that will form part of that consolidated report, of which the committee still needs to adopt, Chair. So I don't see the department coming in for those outstanding areas to be conducted. on the public hearings, Chair. So that's my input, Chair.
Okay. Legal Services, do you want to have a comment or you agree with the directive from committees?
Morning, Chairperson. Since that relates to the ERA bill, Chairperson, I think I agree with I concur with Ari, because I'm here for the NNR bill, and Advocate Jensen advises the committee for the ERA bill, which is a Section 76 bill, and the NNR one is a Section 75. Thank you, Chair.
Okay, thank you very much. That is the guidance that we get, honorable members, that it was just a thought so that we are open to the public, is that when we do the consolidated report and adopt it, we will adopt it with what is proposed as a way forward. If the way forward is that we must reconvene those areas, it will be contained in the consolidated report. Before I give the department, is there any comment? If there's anyone who wants to make a comment, I see the hand of Honorable Mashaule. Is there anyone else going? 1, 2, 3. Okay, I close on this one. Honorable Mashaule.
Thank you very much, Chairperson, and good morning to you and the members, the media, and the department. Chair, I do think that we can proceed with NNR bill. However, when we stopped the ERA bill on those 3 areas, not stop for a lack of a better word, it was as a result of Parliament not having done its work in terms of mobilization. And that's what we said to the media when they asked why did we stop the 3 legs. And we did say, Chair, we will consult with Parliament whether they will allow us to do the 3 areas before we conclude with the public hearings. I should think that that feedback on whether Parliament has agreed or did not agree should come from your office at an appropriate time. Without that guidance now, we can't expect the department to come and respond in piecemeals, because it will necessitate that when we are granted to go back, they come back and respond again. And to me, it's a waste of time. So let's get the guidance first from your office, which would have gone to Parliament and look for advice. If Parliament has said we can't go back, that's well and good, let's proceed. But if they say we will go again, to proceed now may be a waste of time, since we don't know what those 3 areas may have as submissions. Thank you very much.
Okay, can we agree, honorable members? I see your hands. Let's allow the response on the NNR, and then when we deal with the ERA bill, we will take this as also a, what you call it, a point in limine, as a point of priority, and then based on what we agree on, we then take it from there, including the issue of the public hearings. Can I then give the department to respond? We are on the NNR. What we will do, honorable members, is to allow the department to, I request that we take as much notes as possible. And then we will go for questions of clarity. The department will respond on those questions of clarity. And hopefully by that time, if we are done, we will then deal with the issue of the ERA bill. Can I give the department DG? I hope if I don't leave, I can't say someone higher than in the office. Like
Recording
you,
in
maybe.
progress.
Can I give you DG on your team?
Thank you, Honorable Chairperson. Good morning to you, and good morning to the honorable members. Chairperson, I won't waste any time. The team is in the meeting led by DDG Ntokozo Nwabe. They will get straight into presenting our responses on the NNR bill. Thank you.
Thank you so much, Honorable Chair, honorable members. Good morning. Good morning, DG and colleagues. From our side, Mr. Zugile Zibi, who is the lead drafter on this bill, will take us through the presentation. He is flighting from his side. Mr. Zibi, if you can please flight the table.
Can I be given rights to project, please?
You've been given, sir.
Thank you, Honorable Chair.
Is my screen showing your side?
Yes, yes, thanks,
Yes.
colleagues.
Thank you very much, TDG, and thanks to the honorable members. We've structured our presentation of the comments following the outlay of the bill itself. We will start with the long title, go to definitions, and run through the sections where we've received comments. And towards the end, there is a section that deals with general comments, which we will also make some proposed responses on. On the long title, there were two main comments, and they were made by the National Nuclear Regulator as well as NUMSA. The first comment deals with the deletion of the word nuclear from the long title, just in the text that deals with all decommissioning of nuclear facilities. So that word nuclear there, they were proposing to delete that, and we support that proposal to delete the word nuclear in that text. The second one from NUMSA, it deals with the fact that although the bill clause 2 deals with decommissioning and closing of national defense force facilities, equipment and machinery, or scrap for civilian use, the bill's long title does not feature this. So our comment on that is that we are in support, and we have revised that long title, and we have a proposal in terms of that. I will move from the long title and go into definitions, which is a little bit of a long section. The first definition where we received quite a few comments is on activity, the word activity. There are 3 comments on this. One is from ESCOM, another one from the National Nuclear Regulator, and another one from an organization called the FSE. I think it's Federation for Sustainable Environment. So on the one from ESCOM, the comment was around changing of the word activity to a word activities as per the IEA glossary, because the glossary refers to facilities and activities to avoid confusion and activity measured in becquerel. This comment, we've considered it and we don't support it. And our rationale is that the current definition already is an IAEA safety glossary definition of activities. However, the approach taken in the bill is to define the term in a singular manner, In addition to that, there was a need for us to widen the definition in order to specify additional activities that are not covered in the IAA safety glossary, such as the items that you see under number D and E of the definition of activity. The D item deals with manufacturing of design packages intended to be stored, intended for storage or transport of radioactive material. The E deals with the site evaluation, design, manufacturing, construction, commissioning, operation, and decommissioning of facilities. So if we can move right along. A comment from the NNR deals with the issue. It mentions that the definition of activities limiting the application of the Act and should cover activities that are relating to irradiating apparatus. On this one, Chair, we've also not supported this comment purely for the reasons that irradiating apparatus are currently under regulation in South Africa, and that is done under the Hazardous Substances Act. Further, the comment from NNR, we're also proposing to use reference of radioactive in one word instead of radio hyphen active. And this comment, we've noted it, and we need to, we advise, Chair, that change needs to be agreed upon by the Office of the Chief State Law Advisors. So on that one, Chair, we would like to propose that it be dealt with by our colleagues at Chief State Law Advisors. The next one, Chair, is from FSE, which is a comment that was on the asking whether the definition of activity in terms of that subparagraph of the amendments includes the site rehabilitation of radioactive mine residue areas. And indeed, Chair, we've responded to say, yes, it does. That section includes site rehabilitation of radioactive mine residue areas. Moving right along, Chair, there is the next definition is for a word administrative fine. There, Chair, the comment came from ESCOM, and it was proposing to change administrative fine to enforcement in line with the IEA safety glossary. And this comment in the glossary defines this to mean an application by a regulatory body of sanctions against an operator intended to correct and, as appropriate, penalize non-compliance with conditions of an authorization. We've noted this comment, Chair, and our definition, our rationale is that the definition of administrative fine is preferred than that of enforcement, since non-compliance enforcement measures are taken by inspectors. These are non-financial in nature. And in section 47, we have an introduction of monetary sanctions for the first time. And therefore, we've advanced a revised definition of the administrative fines to provide more clarity. Moving along, there's a definition for authorization, where we received a comment from ESCOM that notes that the IEA glossary uses the term license, which is defined as a legal document issued by the regulatory body granting authorization to perform specified activities relating to a facility or activity. In this one, Chair, we've noted the comment and we don't support. And our rationale is that the legal basis for the issuance of various authorizations will be anchored in the Act upon promulgation, hence no definition of license. We'll move along. The next one, Chair, is on as well on authorizations. However, it's specifying nuclear vessels license, where ESCOM was noting a typo and proposing a change. We've noted that comment and we support it. And as a department, then we propose that what is contained in the bill as nuclear license, a vessel's license, be amended to read nuclear vessel license under section 1BC. The next one is on authorization holder, and also the comment came from Eskom, and it was noting that the glossary uses the term licensee, which is the holder of a current license. The licensee is a person or organization having overall responsibility for a facility or activity. And we've noted this comment, and our write-up on it was that the legal basis for the issuance of various authorization, again, will be anchored in the Act upon promulgation, hence no definition for licensee. And the use of the term authorization to cater for all forms of licenses, hence reference to an authorization holder. Then, so what this means that the authorization holder is a licensee. So there's no need to have both in the same act, in the same bill. Then the next one is on authorization to manufacture, which is a comment that came from AIFSA. I don't remember the full name now, but I'm sure we can get back to that. The comment was suggesting that the consideration of certification / licensing of personnel should be considered under that authorization to manufacture. We've noted the suggestion, and our write-up reads, authorizations are issued to applicants, permitting those applicants to undertake those activities through their operating procedures. And that's why maybe there's not much of a strong support to have this included under that authorization to manufacture. Again, another comment on authorization to manufacture came from Eskom, where the comment inquires why differentiate between nuclear safety and radiation safety, since the IAEA applies safety, which encompasses the safety of nuclear installations, radiation safety, the safety of radioactive waste management, and safety in the transport of radioactive material. And then in G, the word safety is used, not nuclear or radiation safety. We've noted that comment, and we've clarified that this pertains to component parts that are important to these two aspects supplied by entities that are not necessarily within the scope of regulation of the NNR. And further, that our manufactured component parts may be determined to be important to either nuclear or radiation safety, and therefore may require written permission from the NNR. And that was the rationale around coming with this definition. The next one, Chair, is on clearance. The one on clearance comments are two comments that were received, one from Eskom, one from NNR. The one from Eskom was proposing to define the process for the clearance in the regulations. We've noted that when we are in support, the clearance process is currently defined in safety standards that are issued under the NNR in terms of Section 36, as well as going over to the NNR comment. It notes that the definition of clearance is limited to authorized activities, and it excludes facilities. And then the recommendation is that it should include facilities. We note that comment, we will support it, and we propose the inclusion of the text and facilities after the word authorized activities in the definition. The next one that we have, Chair, is closure and disposal. These are the two comments where there were a number of comments that were received. One was from the Southern African Faiths Communities organization, as well as the Earth Life Africa Johannesburg organization. The comment on both definition of closure and disposal noted that one of the currently unresolvable problems faced by the nuclear industry is that there are no permanent or final disposal facilities in South Africa for long-lived and extremely hazardous high-level radioactive waste, which can take hundreds of thousands of years to become harmless through decay. Further, that the new and revised definitions of closure and disposal result in this contentious issue being sidestepped. We've noted that comment, and we would like to say that these definitions that we came up with are updated to align with the IAEA safety glossary. And then further that the disposal of radioactive waste, including long-lived and extremely hazardous high-level radioactive waste material, is currently managed by the National Radioactive Waste Disposal Institute, which is established under the NERADI Act number 53 of 2008. Moving along on the same topic, the FSC also made a comment that was inquiring whether the definition of closure includes the management of uraniferous waste in mine tailings storage facilities during the closure and post-closure phases of a mine. And our comment there, Chair, is that the definition of closure includes management of all radioactive waste streams in the gold mining sector. Another comment from FSC was inquiring whether the definition of disposal in that section include the emplacement of uraniferous waste in gold mining tailings storage facilities without the intention of retrieval or of the uranium. And there, our comment is that the disposal of all radioactive waste is permitted to be undertaken by the Institute, as I've mentioned above, under the NERADI Act number 53 of 2008. If we can move over to decommissioning. There was one comment from ESCOM that was proposing the definition of decommissioning should include all processes and actions. And we support the comment, and the revised definition is proposed in this aspect. The next one, Chair, is discharges, which came from the NNR. And there we note that the comment was that the definition is limiting, was mentioning that the definition is limiting the application of the Act, that the inclusion of nuclear facility automatically excludes naturally occurring radioactive material and other radiation facilities. And the proposal was to delete the word nuclear before the word nuclear facilities. And we've supported this comment, and we are proposing a revised definition. The next one, Chair, is on dosimetry service providers. This one, the comment was noting that this definition is not used in the bill, and this comment is noted and agreed upon. The department does propose the deletion of the definition of dosimetry services provider. The next one is exemption, and this came from Safsay and Ella Jobek. The comment notes that while it is understood that certain sources, facilities, or activities may not pose a significant radiological risk, the power proposed to be given to the regulator to determine that a source, facility, or activity is not subject to some or all aspects of regulatory control on the basis that this is the optimum option for protection, irrespective of the actual levels of doses or risks, is too vague, wide, and unconstrained, and is potentially open to abuse. Further, these shortcomings are compounded by the fact that no provision is made in the NNR Act or Amendment Bill for procedurally fair decision-making in respect of such exemption applications. Further, the comment proposed an amendment to remove the reference to regulator making a determination that a source, facility, or activity is not subject to some or all aspects of regulatory control on the basis that this is the optimum option for protection, irrespective of the actual level of doses or risks. Alternatively, that the specific source, facility, or activities contemplated be clearly described. So our response to this comment is that we note the comment, we don't support it, as these powers are not to be exercised under absolute autonomous or arbitrary discretion. Section number 22 of the bill provides for the process for applying for a certificate of exemption. The process for to consider such of exemptions applications by the regulator is contained in the government notice number R388 of 28 April 2006, titled National Nuclear Regulator Act 47 of 1999, Regulations, Safety, Standards and Regulatory Practices. And the decision of the regulator will be based on a technical assessment done on the source, facility, or activity. The next comment came from ESCOM, which was proposing a change in the words facilities and activities in the definition of the term exemption. And our write-up is similar to above. We don't support this. The current definition in IEA safety glossary of activities. However, the approach that we have taken is to define the term in a singular manner. Additionally, there was a need to widen the definition in order to specify additional activities. And this is aligned to what I mentioned on activity. Now it's coming with the word facility as well. If we move on to the next set, we had comments on the word facility. The first one was from ESCOM, which was noting that the IAEA safety glossary refers to facilities and not facility. And the write-up that you see on the right is similar to what we've just mentioned above, so I will not repeat it. And then a comment from the FSE was mentioning that it was inquiring whether the definition of facility includes radioactive or potentially radioactive mine residue areas and or dumps. And our response is the definition includes radioactive or potentially radioactive mine residue areas and or dumps. The next comment on facility was from the NNR. And the comment notes that the definition has the potential to create uncertainty with regards to types of facilities to be regulated, the exclusion of any and the inclusion of specific reference to uranium mines may cause confusion. And they gave a lot of detail on this on Friday. And this comment we noted, and we are in support to remove. The department proposes to remove the confusion. To remove the confusion, the department proposes a revised definition that removes the following text, the one that starts with comma, some mining and raw material processing facilities such as uranium mines. And it also proposes that any also be removed before the word other places. So this will more or less align with the expectation of the regulator and the concerns that were shared on Friday. The next comment is a comment from Quebec Alert Alliance, which is the comment notes a concern about the independence of the regulator and that to assign a responsibility for protecting the environment and public health to the minister responsible for energy is not ideal. The proposal is to change the reporting of the regulator from the Minister of Energy to the minister responsible for the environment, or possibly to the minister responsible for health. We don't support the comment. Our rationale is that the independence of the regulatory body is not absolute. The functional independence of the regulator remains protected in the Act. And the minister and entities responsible for the promotion of nuclear technologies do not play a part in the decision-making processes of the regulator. Further, that the bill seeks to ensure security of tenure of the CEO and the board by proposing longer periods of service, and that the funding of the regulator is not subject to the minister alone, but it is a national appropriation. Chair, on this one, would like to indicate that this comment on the independence is going to come a number of times as we go along, and our rationale is the same in terms of what we've read here. Then the next one is non-ionizing radiation, which is a comment that came from the NNR. And that comment was noting that the definition of non-ionizing is not included in the bill, and that this definition is necessary to clarify the extended definition of radiation, which is introduced in the bill. So this comment is noted but not supported. The term non-ionizing radiation is not used in the bill except for being referred to in the definition of radiation. However, Chair, to try and remove this confusion, we've proposed that the definition of radiation should delete the reference to non-ionizing radiation. Therefore, you will not hear the word non-ionizing in the bill in future. And that will provide a lot more clarity, because also organizations such as the IEA, have only a statutory obligation on ionizing radiation. They do not have a legal basis to be involved with non-ionizing radiation. The next one is nuclear accident, which came from the NNR. This comment notes that with the new definition of nuclear or radiation accident, the definition of nuclear accident may not be necessary. And the department agrees with this, it supports this, and the definition of nuclear accident in the Act is proposed to be deleted. The next one is nuclear damage, which is a comment that came from ESCOM. The comment notes that the definition is taken from the IEA glossary. However, parts of the definition were omitted in the NNR amendment bill. Further, the comment proposes an insertion of the following text for correctness in inverted commas, and each of the following to the extent determined by the law of the competent court. And then it goes further with number C, economic loss arising from loss or damage referred to in A or B. In terms of this comment, Chair, we don't support it. We've noted it when we don't support it. And our rationale is that the text is left out because the relevant legal provisions for a claim for nuclear damage are provided in the NNR amendment bill, including provisions for escalation to a competent court. So it would be a duplication to have this here. The next one, Chair, on nuclear damage came from the FSE, and the comment noted that nuclear damage is narrowly defined. However, the comment notes that the NNR interprets nuclear damage mainly in relation to death, personal safety, or injury of person. Further, that the comment notes that the NNR submitted that there is no sufficient guidance with regard to property or environmental damage, and has accordingly proposed an amendment to the definition. We've noted this comment, Chair, and our write-up reads, the definition of nuclear damage has been revised in the bill to align with nuclear liability conventions, which define the scope of liability for nuclear damage. The definition in the Act is constrained and narrow as compared to the liability conventions, and that the department proposes the inclusion of the word loss in section 1LG. The next comment, Chair, is also nuclear damage from ESCOM, and it reads, the comment notes that the definition is taken from IAEA safety glossary, however, parts of the definitions are missing. And further, the comment proposes insertion of the text for correctness, if permitted by the general law on civil liability of the competent court. And similarly to what we've mentioned above, Chair, this comment is dealt with in the sense that the bill itself has relevant legal provisions for a claim for nuclear damage provided for, including provisions for escalation to a competent court. Another comment from ESCOM proposes the following insertion of the following text. The text it reads, which arises out of or results from or is attributable to the ionizing radiation associated with nuclear facilities and activities, including vessels authorized via a nuclear vessel license. So we've noted this comment and we are not in support. And our rationale is that the current definition is an IAEA safety glossary definition of activities. However, the approach taken in the bill is to define this in a singular manner, and that additionally we had to widen the definition in order to specify additional activities that are not covered in the IAEA safety glossary. The last one also from ESCOM is that the comment proposes a definition of nuclear vessel, and we also not in support of a definition for nuclear vessel, and our rationale is that the bill prohibits vessels propelled by nuclear power having a fissile or radioactive material on board, from anchoring or sojourning, entering or leaving any ports of the Republic without a nuclear vessel license. And our use of the term nuclear vessel is confined to a nuclear vessel license. We don't use the term generally in the bill. The next one, Chair, on nuclear facility is from ESCOM. And the comment was noting that the definition is taken from the IEA glossary. However, parts of it of the definition were omitted. And then the comment notes that the following text, nuclear facility, means any facility. And then they were highlighting the words, including associated buildings and equipment, that they were indicating that those are not included within the nuclear fuel cycle, in which nuclear material is produced, processed, used, handled, stored, or disposed of, other than the mining and processing of, or including but not limited to. And we've noted that comment, and our rationale is that the definition is understood to be inclusive of all the structures, such as buildings and items, such as equipment found in such a facility. The next one on nuclear facility is also from ESCOM, is that the comment proposed a new definition of nuclear waste as follows: any facility utilizing nanotechnology and nanomaterials for the safe disposal of nuclear waste or its processing. We've noted this comment and we are not in support. The term nuclear waste is not used in the bill. Just for correction, this comment is coming from AIFSA, which is Economic Intervention Forum of South Africa. The next comment proposes an addition to the definition of nuclear facility to include any facility using nanotechnology and nanomaterials for the safe disposal of nuclear waste or its processing. It's the same as the comment above. The next one states that a comment proposed the inclusion of uranium-238 and thorium. Also, this comment is from the AIFSA. The comment is noted, but it's not supported. The proposed facility is included under section 1NE in the bill. The next comment is nuclear or radiation accident, and it's from ESCOM. This comment notes that the term radiation accident is not defined, is not reflected in the IEA glossary. Further, that the comment highlights that the IEA applies the term accident for nuclear accidents, criticality accidents, severe accidents, and accidents involving radioactive sources. We've noted this comment, and our write-up is that the current definition is aligned to IEA safety glossary definition of accident, and that additionally, there was a need to revise the definition to entrench the role of the regulator to establish safety standards and regulatory practices through regulations that are issued in terms of Section 36 of the bill. And the next one is nuclear or radiation incident, also from ESCOM, where they were noting that the term radiation incident is not reflected in the IEA glossary, as the IEA applies the term incidents. The comment further notes that the IEA defines a nuclear incident as any occurrence or series of occurrences having the same origin, which causes nuclear damage, but only with respect to preventive measures creates a grave and imminent threat of causing such damage. We've noted that comment, and our write-up is that the current definition is aligned to the IEA safety glossary definition of incidents. However, the approach taken in the bill is to define the term in a singular manner, and that additionally there was a need to revise the definition to entrench the regulator's role to establish safety standards and regulatory practices through regulations issued in terms of Section 36 of the bill. The next definition is nuclear or radiological emergency, which came from ESCOM. And this comment notes that this definition is not aligned to IEA definition for a nuclear or radiological emergency. And they provide the definition of the IEA. This comment, the department does not support it, and this definition aligns to the IAEA safety glossary in that the term nuclear or radiological emergency cross-references emergency, which is defined as we have defined it in the bill. The next one is that the comment notes that the definition is limiting the application of the Act as it excludes non-ionizing radiation emergency. And the comment is not supported in this case. The bill does not deal with non-ionizing radiation at all. Hence, our previous proposal that we remove the words non-ionizing radiation from the definition of radiation. The next comment is on nuclear reprocessing facility, and this is by the organization called AFSA. And then it says a comment proposes that alternatively add nuclear reprocessing facility, and the proposal that nuclear fuel reprocessing facility also be considered. We've noted the comment, we're not in support, as we've mentioned above. We believe that section 1NE covers such a facility under a refinement or conversion facility. Then another comment from ESCOM on also nuclear reprocessing facility. It was saying that the comment inquired, why was the definition removed? We've noted that comment, and our rationale is that the definition of nuclear reprocessing facility only featured in the definitions section and was not used in the Act. It is not used in the bill. The next one is on nuclear license, and from ESCOM. And this comment proposed the inclusion of the text nuclear license means an authorization referred to in sections 2 and 21.1. We've noted the comment and we are not in support, and there is no reference to nuclear license in section 2 of the bill. And that's the reason why we're not in support. The next one is nuclear site license, and that comment is from ESCOM. And the comment proposed that the nuclear site license means a authorization referred to in section 2 and 21.2. We note the comment and we're not in support. And again, similar to the previous one, there is no reference to nuclear site license in section 2 of the bill. The next one is nuclear vessel, where a comment proposes that the definition of nuclear vessel must be included in the bill. Further, that the following textual changes were proposed, except under the authority of a nuclear vessel license or a certificate of registration. This comment is noted, but it's not supported. And our rationale is that the bill prohibits vessels propelled by nuclear power having fissile or radiative material on board from anchoring, sojourning, entering the ports of the Republic without nuclear vessel license, and that the usage of the term nuclear vessel is confined to a nuclear vessel license in the bill. And further, we're saying that the inclusion of the text or a certificate of registration is not supported. And the reason is that vessels are regulated under a licensing framework which imposes a strict liability regime, as opposed to a certification framework which imposes a less stricter liability regime. The next one is on period of responsibility, where a comment notes that the definition is cumbersome and a revision may be necessary to make it simpler, clearer, and understandable. This comment came from the NNR. NNR already provided a proposed definition for this period of responsibility, and we are in support. The next one, Chair, is from ESCOM, which notes that a comment proposes an insertion to the provision to read as follows: any activities performed in regard to the nuclear facility or site in question. We note the comment, we're not in support. The IAEA best practice alignment of the NNR Act includes replacing concepts and terminology such as action to activity, and does not apply to changing the word act to activities, which is what has happened in that insertion by ESCOM. Then the next one is also from Eskom, that the comment proposes an addition to the definition to read some other person in terms of section 21. We note this comment and we're not in support, because the use of the word authorization covers all types of authorizations issued by in terms of several sections of the bill. There is no need to cite each section. The next one is on pre-construction activities. This one, the comment proposes a revision of the definition to reference the building of diaphragm walls as opposed to diagram wall, as well as clearance to bedrock instead of clearance of bedrock. This is from NNR. The comment is supported, and the correction will be noted, Chair. The next one, also from NNR, was on the word prescribed. This comment notes that the definition is not necessary as it has a conventional meaning in South African law. This word is already in the Act. We are not really in support of this comment because the definition enhances the interpretation of the Act. The next one, Chair, is on radiation. As we've noted in multiple areas above, that we have the word, when you define the word radiation, it means ionizing radiation or non-ionizing radiation. And it is our call to say we should do away with the word non-ionizing radiation. Anyway, Eskom have made a comment that notes that radiation usually refers to ionizing radiation only. Further, the comment notes that IEA has no statutory responsibilities in relation to non-ionizing radiation. The comment proposed that non-ionizing radiation must be deleted, and this comment is fully supported. The next one is radiation hazard from FSE, and the comment inquires how radiation hazard is defined in the bill. We note this comment, the word radiation hazard is used once in the bill, and hence it is not defined. The term hazard itself has its ordinary meaning. The next definition is radioactive material, and the comment came from Eskom to note that this definition is not aligned with IEA definition for radioactive material. Our response is that this comment is noted and not supported. And the rationale is that there is no definition of radioactive material in the IEA glossary. The IEA safety glossary provides that a national law shall designate its own definition. And that's the reason why we're not in support. And we are providing that definition in the NNR amendment bill. On the next one is from FSE, and that comment inquires whether the definition of radioactive material section listed there and radioactive material section listed there includes uraniferous waste in mine residue areas and abandoned mine dumps. And our response, Chair, is that the definition of radioactive includes waste in mine residue areas and abandoned mine dumps. The next one is site evaluation. NNR have made a proposal to say a comment notes that the definition is limiting the application of the Act as the security aspects of site evaluation is not included. Further, a proposal is made that the definition be amended to read nuclear radiation safety and security of facility or activity on that site. Our response is that we are in support, Chair, of this comment and the revised definition for site evaluation. Shall move on to section 2, which is the application of the Act Declaration of Nuclear Facility. As noted by NNR in their presentation last week, they have made this comment that notes that the heading is limiting application of the Act as it only addresses nuclear facilities and not other facilities and activities regulated by the Act. A comment proposes to delete the word nuclear from the provision to allow regulation of all relevant facilities and activities. We note this comment and we've consulted with the NNR, and there is no need to make further amendments to the bill with respect to this item. In terms of section 2.1a, the ESCOM made a comment that notes that the deletion of siting, the process of selecting a suitable site for a facility, is excluded from the Act. And there we note the comment, and we don't support, Chair. And our rationale is that the IAA Safety Glossary defines site evaluation as analysis of those factors at a site that could affect the safety of a facility or activity on that site. This definition covers the following stages. The first one being site evaluation, which is inclusive of site selection, 2, site characterization, 3, pre-operational, and 4, operational stages. Stage number 1, which talks to site selection, includes the process of selecting a suitable site for a facility within the bill. So we obviously then it means, Chair, that we are not in support of that, because this is catered for. Site evaluation does cater for a site selection as proposed by ESCOM. In terms of section 2.1b, the comment from ESCOM also proposed that the term nuclear vessel be defined. We've noted this comment, and we've provided this rationale before, Chair, above, that says that the bill prohibits vessels and that the use of the term nuclear vessel is confined only to a nuclear vessel license. In terms of 2.1c, there's a comment from NNR that says, that notes that this provision is limiting the application of the Act, as irradiating apparatus are not included in the clause while they are required to be regulated by the Act. We don't support the comment. As we've mentioned above, irradiation apparatus are currently regulated by the Hazardous Substances Act 1973. Section 2.1d, Chair, there's a comment from FSE that inquired whether the radiation source in the paragraph that we've written on the MOO include radioactive mine residue areas or deposits that are currently not regulated by the National Nuclear Regulator. Then we've said no, it does not include that. Radioactive mine residue areas or deposits fall under definition of activity. And then the next one is 2.1d, comment from FSE. It was saying a comment regarding the statement in the MOO, Memorandum of Objects again, found that there are no corresponding insertion in section 2.1d of the amendment. Comment further notes that the section 1d reads by the deletion of paragraphs C and D, with no reference made to radiation sources that pose sufficient radiological hazard to warrant regulatory control, as those that are not under regulatory control because they have never been so, and clarity was sought. We've noted this comment, and the proposal is that the MOO can be revised to refer to section 2.1c as it pertains to radiation sources, to remove the confusion. The next comment came from Kubek Alert. Just check if it's a bit of a long comment, but it says a comment notes that the proposed amendment aims to exempt naval vessels from regulation by the regulator. Further, the comment notes that this exemption is entirely unacceptable, as the mandate of the NNR is to protect the public and the environment, whatever the source of the risk is. The comment notes that such vessels are potential risks in terms of radioactive substances, and the standards and safety procedures of foreign navies cannot be known with any certainty. The comment proposes that it must be mandatory that any such vessels fall under the scrutiny of the NNR. A comment notes that it is conceivable that a state may designate any vessel as a naval vessel, and via diplomatic channels have it invited into South African waters and harbors where NNR would have no authority to regulate it. The comment further notes that allowing this loophole is extremely dangerous, and as it would allow the undermining of the authority of the NNR, potentially rendering it incapable of fulfilling its mandate and purpose in certain circumstances. So our response is that we're not in support, Chair, and that foreign naval vessels that enter the Republic's waters enter the country under the relevant diplomatic protocols fulfilled through the Department of International Relations and Cooperation and the South African National Defence Force. We've provided a detailed write-up on this in the MOO, Chair, in the sections, new sections 2.2e, is provided in the MOO section 2.2.14 up to 2.2.16. And we don't have any additional input to make on this item, Chair. The next one is 2.2f, which is also from Quebec Alert Alliance. And it states, a comment notes that the insertion of the new section 2.2f is deeply problematic. The NNR has taken on the role of providing security and safeguards and has been doing so for many years, despite it not being clearly assigned these duties in the Act. And then if the comment further notes that it would be wasteful and highly inefficient to duplicate skills and equipment in the DMRE and the NNR. We don't support this comment, Chair, and the responsibility for the implementation of safeguards agreement in fulfillment of international obligations is a state responsibility, and that is currently domesticated through the Nuclear Energy Act, and the provisions of those of that act are what we utilize to handle the matter, and hence the reason not to cause any confusion within the South African legal environment by having a duplication of those being stated in two laws. The next one, Chair, is on section 5, next set of comments, section 5, which is objects of the regulator. The first comment was that from NNR was that a comment recommends the deletion of the word nuclear from the provision to allow regulation of all relevant facilities and activities, which is a comment that we support, and the word nuclear is proposed to be deleted. The next one, Chair, from ESCOM, it notes that the roles and responsibilities of the regulator are not clearly defined, and that the document states that the regulator should be responsible for, firstly, the protection of persons, property, and the environment. Secondly, the health and safety of persons, property, and the environment. Thirdly, health and safety related to workers, the public, and the environment. And number 4, the safety or security of persons, property, and the environment. We've noted this comment. We will not in support. We believe that the objects and functions of the regulator are clearly articulated in terms of sections number 5 and section number 7 in the NNR Act, as well as what's in the bill. The next one is 5B from Quebec Alert Alliance. It's a comment that notes a proposal to exempt vessels propelled by nuclear power or having radioactive material on board from regulation by the NNR. We're not in support of this comment, Chair. Our rationale is that the applicable regulatory scope has been consolidated in the insertion of the words in bracket there, contemplated in section 2.1 of this Act. That text is including the text, vessels propelled by nuclear power having radioactive material on board, with no such exemption of vessels being proposed. Then section 5E is a comment from ESCOM. A comment proposes the revision of the provision to read, fulfill national obligations in respect of international legal instruments concerning nuclear and radiation safety. And we support this comment. The next comment is from also ESCOM. It notes that both radiation and radiological emergency terms are used throughout the bill, which is confusing. And a comment proposes that for consistency, we must apply the correct term. And NNR made reference to this during their presentation on Friday, and we are in support of using radiation emergency moving forward. And such changes would need to be considered for effecting in the bill if it is supported. The next one, Chair, is on section 7, functions of regulator. The first one is on 7H, which is that a comment from ESCOM proposes the use of a detailed reference such as regulations for the safe transport of radioactive material, which is an IEA transport regulation standard number SSR-6. We note this comment, we will not in support. Our rationale is that the document is an output of expert consensus reached and cited at the time, and this gets reviewed and periodically, and therefore it may change numbering at some point. Therefore, it is not wise to cite a direct number reference at this time. The next one, Chair, is from FSE on 7BJ. That one, the comment inquires whether section 6BJ also apply to mine residue areas contaminated with radioactive waste. And we note this comment, and then our response is that the section applies to mine residue areas contaminated with radioactive waste. The next one from ESCOM on 71P, the comment notes that this is a duplication of 8.0, and we're not in support of that. We note that there's a difference between National Dose Register as well as the Register of Occupational Dose by Workers. But just to read it up, National Dose Register is different to a National Register of persons authorized to carry out activities under this Act. The latter refers to the repository of authorization holders, whilst the earlier refers to a collection of occupational dose by workers. The next one, also from ESCOM and 71Q, is that the comment notes that paragraph 21C does not address a national register of radiation sources. We note the comment, and a revised provision is proposed. The next one is on 7.2, which is from Safse and Ella Joburg. There's a proposal that Section 2 of the NNR Act should be retained in order to promote the foundational constitutional principles of accountability, responsiveness, and openness, and to ensure that Parliament can effectively carry out its constitutional oversight function by receiving such reports timeously. We note the comment, and we're not in support, Chair, and we noted that our rationale is that the removal of the time frame requirements is to align the bill with the provision of the Public Finance Management Act 1999, specifically Section 55(3), and it is not to avoid accountability and transparency. The next one is a comment from ESCOM on 7.2. It says the comment also notes that the word shall denotes mandatory provisions in the Act. However, a mixture of the following words, shall, should, must, may, and will, is used in the document, which is not aligned with the rules of statutory documents. We note that comment, we're not in support, Chair, and our rationale is that the use of the cited words is permissible in South African legislation. The next set, Chair, is on Section 8.4a. First comment is from AFSA. And the comment proposes the removal of members of organized labor, business community from the board. The comment further proposes that the interest of communities affected by nuclear facilities be dealt with through Section 17.6a, B, as well as 22.2 on establishing a public safety information forum. In this one, Chair, the second part of the comment, we don't support it because those sections are dealing with public participation when you have an application made, and that then the department supports the position of the regulator, wherein there is a consideration for independent board members in line with other regulators. Go to the next one, 8.4a6 from AFSA. It notes that the comment notes that there are too many board members and there's a need to reduce the number to a total of 8 or 9. And then the comment further proposes a total of 5 board members. And here, Chair, we don't support the comment, and the rationale is that this is to establish proper balance and representation. The next one, Chair, is that AFSA also made a comment on the Chief Financial Officer being part of the board. It proposes a removal of the Chief Financial Officer from the board. We note that comment. The proposed amendments are intended to align the bill with the current corporate governance principles, and that the chief financial officers of entities are included in the membership of board of directors, and legislation provides for the suitability of members appointed to the board. The next one, Chair, is 8.7, which is from Kubeka-led Alliance. And the comment notes that the amendment process is removing the clause that states which may include representatives of the relevant committees of Parliament. The comment proposes that due to the importance of transparency and parliamentary oversight, therefore this clause must not be deleted. And further, that a comment further proposes a strengthening of the above provision to read which must include representatives of the relevant committees of Parliament. And lastly, a comment notes that a secret panel appointed by a minister is so responsible for compiling a short list is incompatible with the principles of transparency and administrative justice. Chair, we don't support the comment. The deletion that we were proposing of the provision was to entrench the separation of powers between Parliament and the executive, and to minimize possible delays in the appointment of the board. The next comment, Chair, is from AFSA, and the comment proposes a narrowing of scope of the qualification to nuclear safety and nuclear technology. We don't support the proposal, Chair, because the narrowing of qualification scope limits the pool from which to choose qualified candidates when appointments need to be made. And then the next one, Chair, is a comment that is shared between Kubeka-led Alliance and Project 90. And it notes that the proposed amendment adds a line that board members must, for it be persons who are committed to the objects and principles as enunciated in the Charter and Code of Conduct of the Regulator. And further, that the comment further notes that the Code of Conduct is explicitly for employees, and it is entirely inappropriate for non-executive directors to be bound by the provisions in that document. For example, in paragraph 631, it requires those covered by the Code of Conduct loyally execute the policies of the government of the day. And then a comment proposes that loyalty to the government is not something board members of an independent regulator should be required to have, and it would put them in conflict of interest between the purpose of the NNR and this loyalty to government, and hence minister of the day. Our response there is that we note the comment. The charter referred to in the bill is the board charter, which ensure that the board exercises full control over significant matters, including the regulator's vision, mission, and values, strategic objectives, strategic plans, annual budgets, and performance monitoring against set objectives, as well as its design, integrated report, and annual financial statements. The charter is reviewed annually and sets out the responsibilities of the board to align with the provisions of the Public Finance Management Act 1999, which set out the responsibilities of the accounting authority. The Code of Conduct may be for employees. However, the prime purpose of the Code of Conduct is to promote a culture of ethical behavior and to instill public trust and confidence in all those who act on behalf of the NNR, which applies to the board members. The next section, Chair, is 14, and the comment is from Kubeka-led Alliance. And this comment proposes altering 14.1 to allow delegation of powers to a single director or the CEO. The comment notes that this is deeply problematic as it would allow any power contemplated in the Act to be delegated to an individual, including the CEO. So we've noted that comment, Chair, and we're not in support. A delegation made is to either the CEO or the director will be subject to conditions determined by the board, and the board will still have the power to perform the function that it delegated. On section 15, which is the chief executive officer of the regulator, the comment came from Quebec Alert Alliance that proposed that the minister may discharge the CEO in consultation with the board to avoid undermining the authority of the board of the executive. Now, that comment, Chair, we don't support it. The insertion of after consultation does not mean the minister acts arbitrarily. The board is consulted before a decision to remove the CEO is made. The views and recommendations of the board will be considered by the minister. That's our comment. On section 17, which is funds of the regulator, ESCOM made a comment that notes that the current provisions of the Act in section 52 provides for criminalization for non-compliances with the Act. The comment proposes that a legal opinion is required to confirm whether the regulator may enforce a system of administrative fines via directives and criminalizing certain aspects of non-compliance to requirements addressed in regulatory documents. Further, the document proposes that the judiciary process for appeal must also be specified. We note this comment, Chair, and our write-up is that the bill provides for regulations to be established to prescribe administrative fines, and as per practice, these will be subjected to legal scrutiny, including a legal opinion. The judiciary process to follow is linked to provisions on appeal to the High Court against board's decision, as stipulated in section 46 of the bill. The next comment section is section 20, restriction on certain activities. There's a comment on 21 from ESCOM that proposes a revision to the provision to read, no person may site, construct, operate, decontaminate, or decommissioning a nuclear facility except under the authorization of a nuclear license. And we don't support this comment, Chair. Our rationale is that the authority rests with the organization, in this case NNR, and an authorization such as a nuclear license is one of many such tools issued by the NNR. The next one is on section 23 from ESCOM, which is a comment that proposed a revised section 23 as follows. No person may manufacture or cause to be manufactured component parts relating to nuclear and radiation safety as prescribed in the regulations except under the authorization to manufacture. We note the comment and we support it, including the text and radiation after the word nuclear. And we just say that the removal of or a nuclear license is not supported, as this would be additional red tape for those who can add this onto an existing authorization and an administrative burden for the regulator to manage a proliferation of authorizations when this can be avoided in such a case. The next one is 24, Chair, and comment by ESCOM. And the comment proposes that a nuclear vessel must be defined, and it further notes the text that except under the authority of a nuclear vessel license or a certificate of registration. We note the comment and we say the bill prohibits vessels propelled. So we've gone through this type of a comment before, Chair, at least 2 or 3 times before. It's about the nuclear vessel license and where that word is used and the need to define it. Number 25, the comment from NNR proposes the consideration should be made to include the phrase other than that listed in subsection 24 to prevent confusion that all vessels require a COR, which is a confusion. The comment is supported, and the department proposes that the insertion of the proposed text be considered. The next one, Chair, is on 29, which is a comment from ESCOM. This comment notes that this section should address the provisions of all authorizations listed in 2.1, and that the provision for nuclear site license are not addressed. So we don't support this comment, Chair. The provisions, our rationale is that the provision deals specifically with the yet to be prescribed technical services and not all the other authorizations that can be issued through the bill. This narrow scope does not include matters of nuclear site license. And then the next section we go to is section number 21, and comment is on 21.4 from NNR, that a comment notes that the cross-reference to subclause 25 is incorrect. The comment proposes that the reference should only be made to 26 as to make sense, as persons with existing authorization do not have to apply for a nuclear vessel license or a new certificate of registration. We support the comment. The cross-reference is proposed to be amended as proposed. The next comment is on section 21.6 by Quebec Alert Alliance. And this comment notes that the amendment of section 21 of the Act deals with the public participation, wherein a right is enshrined in the Constitution. However, the process as described is inadequate. A comment raises a concern of a non-requirement in the bill that does not provide for any responses to be given to the issues raised during public consultation, such as the issues and responses report requirement as part of an environmental impact assessment. A comment proposes that the Act should be amended to be more explicit about the public consultation process, including that reasons must be provided for decisions in line with BAJA, as well as written responses to any substantive issues raised during the consultation process. And our comment is that we note that comment, Chair, and Section 36 of the bill enables the regulator to develop regulatory practices, safety and related security standards, published as regulations in terms of Section 47 of the Act of the bill. The public participation process will be addressed as part of these standards. The next one, Chair, is Section 21.11, which is a comment from AFSA, and the comment proposes an inclusion of a new Section 21.11 to read, an applicant for a nuclear license shall receive a response informing him or her of the status of the application within a period not exceeding 90 days from the date of receipt of the application. We not in support of this comment, Chair. There are several factors that are considered in the assessment of an application, such as the type of an authorization applied for, a number of licensing stages, and or possibly a pre-licensing activities such as siting and design assessments. The timelines for the review of applications depend on various organizational factors such as staffing, the quality, comprehensiveness, and availability of submissions required from the applicant, the schedule of documents, submittals, and the proposed type of technology. So that is our rationale, Chair, for not supporting that comment. The next section is Section 22, which is application for certificate of registration, exemption, authorization to design, or authorization to manufacture. And in Section 22.2, there are several comments. The first one is from AFSA. It notes that there's an incomplete sentence, Section 22.2, and proposes to complete this sentence by copying in the text from the existing Act. We note this comment, Chair, and we just indicate that the bill proposes amendments to Section 22.2 only, and Sections 22.2A and B of the Act are not being amended. This makes it appear as though the text is missing, but it is not, because The text that is not amended is usually left out of the bill. The second comment is from NNR, and it notes the inclusion of the word must in this clause will defeat the principles of regulating facilities and activities commensurate with the risk associated with them. Therefore, a graded approach is needed. And that the comment further notes that the new requirement will constitute unnecessary red tape by the regulator, which is not warranted and not good regulatory practice. The comment proposed that the word may as a discretion should be considered so that the regulator can make a decision on a case-by-case basis, taking into account the risk associated with the activity in line with the graded approach. So we note this comment, Chair. The bill proposes, we note and support what NNR are saying, Chair. And the department proposes that we retain the word may as it is in the Act already. They spent some time explaining this last Friday as well. The next one, Chair, is Section 23, which is conditions relating to authorization. Its comment is from AFSA, and it advises to avoid a situation where conditions and restrictions are arbitrarily imposed, leading to litigation, and proposes the insertion of a new 23(3)(d) to read reasons based on objective data or evidence to be provided for imposition. Here, Chair, we note the comment and we support, and the department proposes a new insertion of Section 23(3)(d). The next one is Section 25, which is transfer of authorization. And this comment notes that Section 25(1) and 2 may need to be harmonized for regulatory certainty. The comment proposes that 25(1) may need to be deleted, and that in Section 25(2) and 3, the word responsibility be replaced with authorization. So furthermore, the comment proposes the following text to replace 25(2) and 3. So 2 now reads, an authorization holder may not transfer authorization for regulated activities to another person or entity without the written permission of the Chief Executive Officer, subject to approval by the board. And then number 3 reads, a person or entity to whom the authorization for previously regulated activities is to be transferred must apply to the regulator as prescribed. Chair would support this comment, and we propose that these new 2 and 3 be the proposed 2 and 3 be the new 1 and 2, and that there's no 3 in the there's no 25(3) in the future bill for consideration of the committee. In Section 25(2), Chair, there's a comment by Quebec Alert Alliance. The comment notes that the bill proposes making a fundamental change to the transferability of the authorization, whilst the current version of the Act wisely prohibits this. A comment raises concern that the CEO alone may approve a transfer of responsibility, and this opens the door to extremely undesirable scenarios. A comment notes that the process of providing an authorization that involves ensuring that the applicant has the financial resources to carry out all required safety measures and potentially remedial actions required. Further, the comment notes that this is a process which involves deliberation at board level, and it is highly undesirable to permit any scenario where the CEO or any other individual authorizes the transfer of a responsibility to some third party. And then a comment proposes that the authorization holder should at all times be fully responsible for all obligations in terms of the authorization issued. And this proposed amendment should be discarded. So the comments are noted, Chair, and the department proposes a further revision to the section to prohibit a transfer of authorization for regulated activities to another person or entity without written permission of the Chief Executive Officer, subject to approval by the board. And then Section 26A, what we're proposing above, Chair, is something that is aligned to the new input by the NNR. And then further, that Section 26A of the bill provides for financial resources for remedial actions to be made by applicants of or authorization holders. Since the person to whom the responsibility is to be transferred must apply to the regulator as prescribed, this section is applicable to such person or entity. The next one, Chair, is on responsibilities of authorization holders with section 26(1)(d). If the comment came from ASA. The comment proposes to provide training and information on nuclear safety to staff. This comment, we note it and we don't support, Chair. The general couching of the provision 26(1)(c) is wide enough to include all forms of necessary required nuclear or radiation safety training and information provision in line with the nuclear safety culture practices. The second one, which is 26(1)(j), also from AFSA, proposes to add a new provision such as maintain a register or log of staff training and information and evidence of the implementation of the self-inspection program. We note the comment, we don't support it, and our rationale is that the regulator requires authorization holders to maintain and keep records of their fulfillment of their prescribed responsibilities through enforcement of documents and quality management systems. 26(h) is financial responsibilities of applicant for and holder of authorizations. 26(a)(1), there's a comment from AFSA, which reads, the comment proposes that the manner in which the regulator ensures financial resources for rehabilitation are always available needs to be defined. And last week, Friday, they made an example of an escrow account. Chair, this comment is noted. The manner in which financial resources must be made available will be defined by the regulator through license conditions and may also be defined through regulations. And then we go into 26(a) as in general comment that also from FSC that notes that this section makes a provision for authorization holders
Is it me who is lost?
No, Chair.
Honorable Chair, I'm checking with Mr. Zibi. We are struggling a bit with the network in the office.
Sorry?
Mr. Zibi, are you still there?
I'm still here, Chair.
Continue.
I'm sorry for the network challenge. And this one, Chair, our rationale is that the DMRE has assumed responsibility for derelict and ownerless mine sites, and as such, it rehabilitates 3 such mines annually using public funds. That's our write-up on this comment. The next one is on 26(a)(3), a comment from ESCOM. This comment notes that this condition is applicable to Quebec long-term operation. The comment also notes that Quebec decommissioning fund must be available within the set time frame as determined by the NNRO prior to LTO authorization. And Chair will note this comment, and the provision is intended to be applicable to all applicants for and holders of authorization. Section 28 on fees for authorizations. A comment from ESCOM proposes that the word consultation must be defined to mitigate against misinterpretation. We note the comment, Chair, we're not in support. This word carries its ordinary meaning. The next one, Chair, is on section 29, which is financial security by a holder of a nuclear license. A comment from AFSA proposes that no consultation with the Minister of Finance is required, as this is a technical issue with only the quantum of the financial security being the concern of the Finance Minister, and this is covered in the next subsection. Further, a comment proposes that there should be a subsection a subsection where the board is required to maintain a list of nuclear facilities with their categorization, and each authorization for a facility should put that facility in a particular category. And then lastly, a comment proposes that the section on financial resources must draw from the subsection proposed above. We support the comment, Chair, to have the first section that doesn't require for the finance minister to be consulted in making a determination of those facilities, category of the facilities. Consultation, our rationale is that consultation with the Minister of Finance was recommended to ensure that Minister has a full appreciation of the categorization exercise by the regulator before the levels of financial security are determined. However, this can still be done under Section 29(2). And then the department proposes to revert to the original provision in the Act. The second proposal, Chair, to have a list of nuclear facilities, maintain a list of nuclear facilities not supported. The regulator, in terms of Section 39(1), obligated to keep a record of particulars of all nuclear installations. The reading of this section is wide enough to include the category of such installations that has been proposed. The next section is 30, which is strict liability of holder of nuclear license for nuclear damage. 33, there's a comment from EFSA that proposes that it must be clear that the liability is transferred to the license holder of the site to which the material has been transferred. Otherwise, it remains hanging in the air. Our response is that we note this and we're not in support. Our rationale is that the provisions provide clarity that the liability of one operator terminates when that material comes to the site of another operator. This ensures that at all material times, there is someone liable for the material. The next one, also on 33, is from EFSA, is that further the comment inquires on what mechanism is put in place to verify and ensure that the new holder of the material has the correct quantum of financial security. We note this comment, Chair, and our rationale is, our write-up is that in terms of the provisions of the Act, no person may be granted a nuclear license without the regulator having satisfied itself that the required amount of financial security has been put in place in a manner prescribed in Gazette number, the Government Gazette number R1342 of 18 October 2019, categorization of the various nuclear installations in the Republic. The level of financial security to be provided by the holders of nuclear installation licenses in respect of each category on nuclear installation and the manner in which the financial security is to be provided. The next comment, Chair, is on Section 34, which is from a comment from EFSA. It proposes an accreditation of transporters and compliance conditions, regulations need to be developed. Further, that the comment proposes accredited vetted transporters should be allowed to transport radioactive material. And lastly, it proposes that the method of securing the cargo need to be developed through regulation. We note the proposals, Chair, and our write-up is that Section 7(1)(h) and 36 of the bill empowers the NNR to guide safe transport of radioactive material in line with IAEA prescripts, and that authorizations issued by the NNR incorporate conditions that require holders to implement IAEA transport regulation prescripts. The regulator vets and approves such authorization. The next one, Chair, is on Section 37, which is duties regarding nuclear or radiation accidents or incidents. First comment is from EFSA. It proposes to use objective evidence with a transparent methodology as opposed to a subjective opinion, and that the following text then is proposed. in such manner as it deems fit, define particulars of a period during which and the area within which in its objective assessment. So we support this comment, Chair, and the department proposes a revision to this section to ensure that the decision of the regulator is based on its objective assessment instead of an opinion. Next comment is from ESCOM Chair. It proposes that the NNR responsibilities must be reflected in the integrated Quebec nuclear emergency plan. We note this comment, and any instrument that is affected by the changes in the legislation will have to be accordingly aligned. That is our comment, Chair. The next one is on section 38 on emergency preparedness and emergency response. First comment is on 38.1 by AFSA, who propose that a link between risk assessment and a categorization of installations to avoid a secondary process to determine whether or not this possibility exists. Further, a comment proposes a revision to this section to read, where the possibility exists that a nuclear or radiation accident or nuclear or radiation incident affecting the public may occur, as determined by the category risk assessment of the installation. The regulator must direct the relevant authorization. Here, Chair, we note the comment and we don't support. And our write-up is that the provisions of the bill define a nuclear or radiation incident and nuclear or radiation accident using a yardstick of safety significance levels measured in effective dose, which are to be prescribed in section 36. The approach uses radiation dose levels as opposed to categorization of installations. And further, that the radiation dose and risk limits for the public and workers relate directly to the objectives of nuclear or radiation safety, and are therefore considered the most fundamental yardstick against which to assess nuclear safety, contributing towards a more consistent and transparent basis for regulatory decision-making. The next one, Chair, on 38.2 is a comment from Quebec Alert Alliance. It raises a concern to Section 28 of the Act as it relates to emergency planning and reads in part, the regulator must ensure that such emergency plan is effective. Further, the comment raises a concern that this is problematic as it is silent on what action the regulator must take if the plan is not found to be effective. The comment raises another concern that the NNR has no power in law to compel other government bodies to participate in the drills and hence is unable to ensure the plan is effective. And that the comment proposes that the Act should be amended to bring it into line with international best practice by prescribing that should the NNR find non-compliances with the emergency plan requirements during a drill, that the authorization holder is given 90 days within which to repeat the drill successfully, failing which the authorization is immediately withdrawn. This is how the United States Nuclear Regulatory Commission deals with such a situation. The comment notes that the current practice on the ground and wording of the Act allows an attitude of impunity from authorization holders when emergency plans are found to be non-compliant. The response, Chair, is that this comment is not supported by us. The rationale is that the detailed requirements on emergency planning and response are provided in each authorization and condition. Further, NNR have developed a requirements document, RD14, which is titled Emergency Preparedness and Response Requirements for Nuclear Installations to guide authorization holders. NNR enforces compliance to the provisions of the Act as it pertains to the authorization conditions, and the bill now provides for administrative fines to be prescribed and levied as a corrective measure. Further, Chair, the department has commissioned a study on the Level 1 Integrated Disaster Management Plan for minerals and energy sectors to establish the disaster management function. This will identify relevant role players and stakeholders that can contribute to the prevention, mitigation, and reduction of disaster risk. The next one, Chair, is general on 38 from the FSE. The comment inquires whether the bill provides for emergency preparedness and response in the event of catastrophic failures of TSFs containing uraniferous waste and the impacts on the mining affected communities and the environment. We note this comment, and our response is that the bill provides for emergency preparedness and response on storage facilities containing radioactive material. The next comment is on 38.5 from AFSA. It proposes that the emergency preparedness plans must ensure there is a mechanism for accounting for people on the site at all times. And further, that a comment proposes a revision to this section 35.5a to read a mechanism to track the names, identity numbers, contact details of next of kin of all persons on the nuclear facility at any time. We note this comment, Chair, and we don't support. The regulator requires authorization holders to maintain and keep records of their fulfillment of their prescribed responsibilities through enforcement of document and quality management systems. The next one is on 38.9a, a comment from ESCOM, which proposes that the text should read Disaster Management Act and associated amendments. We don't support this proposal, Chair. A reference to principal legislation includes subsequent amendments to that legislation as well as regulations promulgated thereunder. The next one is on section 38.12, which is ESCOM noting that this reporting condition will result in a change to the integrated Quebec nuclear emergency plan. We note that comment, Chair, and any instrument that is affected by the changes in legislation will have to accordingly align. Section 41 on appointment and powers of inspectors. There's a comment on 41.1 from AFSA that proposes that the training and certification of inspectors to certain IEA standards needs to be strengthened and specified. We note the comment, Chair. Development of necessary regulations will be pursued to ensure the training and certification concerns that are addressed. The next one is section 46, which is on the appeal to High Court against the board's decision and notice to minister. This comment is from Outer. And the comment reads, it is imperative that the legislative framework and governance structures around nuclear energy can withstand political interference and uphold the independence of all regulatory bodies, inclusive of National Nuclear Regulator of South Africa. We submit that the bill may pass constitutional muster but lacks substance in addressing the independence of the NNR through proper consideration and implementation of recommendations made by the IEA. Chair, our response to this is that the bill has addressed the matters of strengthening the independence of the regulator by amending the subsequent provisions. The first one is 45, is being repealed to exclude the minister from appeals processes between the regulator and the authorization holders in matters that relate to the regulation of nuclear safety. Section 46 is amended to provide for an appeal process against the decision of the board by submitting an appeal to the High Court. The minister will only be appraised of the lodged appeals and its outcomes. Then that last part, Chair, I'm repeating it. I mentioned it during the definition sections that the independence of the regulator is not absolute. The functional independence of the regulator remains protected in the Act, that the minister and entities responsible for the promotion of nuclear technology don't play a role in the decision-making processes of the regulator, that the bill further seeks to ensure security of tenure for the CEO and the board by proposing longer periods of service, and that the funding of the regulator is not subject to the minister, but it is a national appropriation. The next one is section 51, disclosure of information. The comment from AFSA that notes that the information security in organs of state is handled according to the Protection of State Information Act, implemented through NIS. Adding this section could lead to conflicting requirements. At any rate, the CEO must publish details of applications for authorizations in a gazette and in newspapers. So it would be very difficult to suddenly define which information is confidential unless classified or proprietary, which is covered by other laws. Also, check the AMSCO security instruction for further details of how Protection of State Information Act is implemented in that sector. We note the comment, Chair, and we're not in support. South Africa is a member state to the IEA and has acceded to its legal instruments. There is a need to balance between the constitutional right to public participation and international obligations regarding non-proliferation of nuclear material when considering publishing details of applications for authorizations in a gazette and in newspapers. The next one, Chair, is Section 52, also is from ESCOM. It inquires whether the infringer is the authorization holder, and we note that comment and we highlight the infringer is an authorization holder. Chair, these are general comments that I'll go through. The first one is from FSE, and it inquires about what the criteria to determine whether rehabilitation is required is, and is the dose limit considered in the determination, namely the exceedance of a public dose limit of 1 millisieverts per year. In that one, Chair, we highlight that the determination of whether rehabilitation is required is detailed in the remediation plan, which forms part of the safety assessment report that each applicant for an authorization is obligated to submit to the NNR during the application process. The next one from FSC is a comment that notes the inference that Clause 5 of the MOO provides for the cooperation between the NNR, DMRE, DFFE, DWS is in respect of the monitoring and control of radioactive material in mine residue areas or exposure of communities who live within these areas. Since such cooperation was historically poor, which approaches are proposed to coordinate joint efforts and interventions linked to contaminated mine residue areas and aquatic systems such as wetlands, dams, and rivers. So our comment, Chair, is that there are agreements that are entered into by the NNR with respective departments. These agreements clearly stipulate the specific functions, mechanisms, and procedures for cooperation between the parties. Within such agreements, there are specific measures to be followed should there be non-compliance with the terms of the agreement, as well as dispute resolution in respect of application of the agreement itself. The next comment is from the FSE. It notes that with reference to cooperation, will local and district municipalities be involved in these agreements for cooperation, since municipalities have historically relocated persons on radioactive or potentially radioactive mine residue areas? And then our response, Chair, is that the cooperation agreements entered into in terms of Section 6 of the bill are not restrictive in respect of whom the NNR can partner with, subject to the scope of the application of the bill. There is a general comment also from Outer, Chair, that a comment notes that South Africa is a member state to the IEA, that South Africa also ratified the 1996 Convention on Nuclear Safety. Although IEA is not the South African government, and any recommendation by it are not necessarily binding in the absence of international agreements, as per Section 231 of the Constitution of the Republic of South Africa, 1996. Their findings is utmost importance and made in the public's interest. The comment submits that Parliament ought to explain why the IEA's recommendations had not been implemented and how the Portfolio Committee are going to ensure neutrality and independence of the NNR board. Further, the comment submits that a golden opportunity has been missed to address the independence on the NNR through the current legislative process of the bill. So our response, Chair, is Section 2 of the Amendment Bill seeks to expand the regulatory scope to include naval vessels, nuclear security, the back-end activities of any of the Republic's National Defense Force facilities, and exposure of accrued cosmic radiation. Section 26 provides for responsibilities of holders of nuclear authorizations. These amendments are to align with the IAEA best practice and a recommendation of the INER report. Section 26A makes amendments to provide for authorization holders to set aside financial resources for rehabilitation, remediation, and decommissioning activities in line with IAEA best practices. Additionally, the bill provides for the NNR to regulate decommissioning activities as it was not provided for previously in the Act. Section 38 extends the scope of the NNR in emergency planning to emergency preparedness and response. The amendment empower the regulator to periodically review the emergency plans and update it. And then on the independence, we've read this before, Chair, that this is not an absolute independence and that the functional independence it remains protected in the Act, that the minister and organizations that take part in nuclear technologies are not part of decision-making, and that the bill seeks to secure the tenure for the CEO and the board with longer service, and that the funding for the regulator is not subject to minister, but a national appropriation. There's again a repeat of the comment on independence, Chair, which was shared by Kubekaleta Alliance, Outer, and Project 90 on effective independence generally. So we've noted these comments, and the write-up is the same, Chair, as what we had above on independence. And then on ring fencing, decommissioning, and waste disposal funds, the Kubekaleta Alliance made a comment that notes that international best practice is that a levy is paid for every unit of electricity produced via nuclear. This is not in place in South Africa, despite the existence of National Radioactive Waste Management Agency since 2008. Protecting the public and environment from radioactive waste falls within the mandate of the NNR. However, the NNR is powerless when there are insufficient funds available to implement its recommendations or requirements. The Act should be amended to require that sufficient funds, as determined by the NNR, are paid by authorization holder and placed out of the reach of the authorization holder in a ring-fenced interest-bearing fund dedicated to decommissioning and final waste disposal resulting from the activity related to the authorization. Chair, we note that comment, but we're not in support. And our rationale is that the management of radioactive waste disposal falls within the mandate of the National Radioactive Waste Disposal Institute, and that Section 21(1)(c) of the National Radioactive Waste Disposal Institute Act obligates the generator of radioactive waste to contribute to a fund which will take care of long-term management of radioactive waste. And Chair, maybe to indicate further that the process of establishing that fund and bringing it to Parliament is currently ongoing. Then, Chair, there are a few other comments. Rocha's report estimates on costs of nuclear waste management for various countries. We've noted that the comments from that report, Chair, and that this report will be considered during the processing of the Radioactive Waste Management Fund Bill. And there are some of the natural justice and Outer and Project 90 general comments are also noted, Chair, the ones that are not specific to several provisions in the bill, and that these general comments provided here have been noted, and that these comments do not address specific provisions in the bill and have no bearing on the provisions of the bill. And there are other comments, natural justice comments, Chair, on the rehabilitation of mines And we do make mention that the rehabilitation of mines is catered for by the Mineral and Petroleum Resources Development Act, working in tandem with the National Environmental Management Act, and that the NNR Act and the bill provides for additional measures to ensure the rehabilitation of gold mines that have been radioactively contaminated. Then, Chair, we have a comment also from Natural Justice, which is a proposal to not limit liability. And we note that comment, Chair, and then we want to say it should be noted that it is best practice that nuclear liability for third-party compensation is limited. And this is based on the existing international best practice, whether you're looking at the Paris, Vienna, and the Convention on Supplementary Compensation. All of those conventions, they have that limitation. Further, that government will accept the responsibility as an insurer of last resort for compensation claims in excess of maximum liability in terms of Section 3. This is Section 30. Chair, this is beyond, these are items that are beyond what has been planned for and beyond what has been expected. The Act does provide that the amounts of security be set and revised on a regular basis, and the regulator does do that through the department. And when National Treasury considers as well what the quantum needs to be, there is a factoring of all of these factors before a decision is made. Then lastly, Chair, there's a comment from NUMSA, which was sharing a concern on the socio-economic impacts of the bill, and also requesting clarity on decommissioning. And our response is that we have a socio-economic impact assessment system report on the bill that has been shared. We can share it again if it is not available to other colleagues. And then the financial provisions for decontamination, decommissioning, and closing of facilities, and facilities come from authorization holders. A decommissioning plan is submitted during the application of an authorization and is assessed by the regulator throughout the operational life of an activity or a facility. I'd like to thank you, Chair, and the members.
Honorable Chair, thank you so much. We have come to the end of the table where we have formulated the responses. I do wish, Honorable Chair and Honorable members, to apologize for sharing the documents late this morning. It's because of the volume of work where we had to work throughout the weekend and yesterday into the evening, just to make sure that we cross-reference all the comments correctly from the bill. Thank you so much. Thank you, DG.
Thank you, Chairperson. That's the first presentation. Just to echo DDG's comments and apology, I think from our side, Chairperson would like to apologize to you and the members for submitting some of the documents late. And as indicated, it's because specifically with the ERA, the team had to deal with a lot of the comments, which some of them were substantive, and we obviously did not want to do or bring to the committee work that is not well considered. Back to you, Chairperson.
Thank you very much, DG, and Ms. Ngwabe, as well as Zebi, for the presentation. Without any delay, I know it's a hectic exercise that we are dealing with. Can I check, honorable members, any hands? I see the hand of Honorable Mailem, I see the hand of Honorable Ceza. Is there any other hand? Going one, going two, going three. Okay, it's only those two hands. We are doing the same exercise, honorable members. We are just seeking questions of clarity so that they can help or assist us on the deliberations when we deal with the deliberations, the actual contents of the bill. Honorable Mailem.
Thank you, Chairperson, and Chairperson, thank you to the department for their feedback. I'm sure it will prove most constructive in our deliberations. I just want to dig into the amendment to Section 8, subsection 7, and the concern that was raised by, I think it was the Coburg Alert Alliance, that it didn't foster an independent shortlist of panelists for, or an independent shortlist. Let me back up a step. It didn't create any independence in creating the shortlist for the minister to consider for members of the board. Can the department give us some clarity? I know that a number of other regulatory bodies, for example, ICASA and the Civil Aviation Authority, to name but two, the members of the board, the shortlist is determined by the Portfolio Committee of Parliament, not by the minister. And the minister receives that shortlist, and then he considers the shortlist that is provided by Parliament, which creates a measure of screening and independence, and it's not done in secret behind anyone's back. Could the department give us some feedback as to why they are supporting this amendment that really puts all the decision as to who is on the board, including who is the panel that shortlists members for the board, in the hands of the minister, when this is strictly a regulatory body that we're talking about, and most other regulatory bodies are determined, the shortlisting at least is determined by the Parliamentary Portfolio Committee. Thank you, Chair.
Welcome.
Oh, thank you, Chair. In protest, Chair, I will take my weekend as well to go through the responses of the department, because you can imagine how it has been for us, as hectic as the program it is, Chair, and the number of issues that are raised within the presentation that would then require our brain. I'm sorry for that, Chair. Our brain capacity that will require us to apply our minds. So they are telling us that the documents are received late because they had to have a weekend. Why wouldn't we have some time ourselves to apply our minds on the matters? Because the matters need a thoroughgoing concentration into what they are saying, and so that we can draw and deliberate on them. So in protest, I'll do the same. I will not take it, and so that next time you don't do the same thing. At COGTA, it was the same. I think that government is just reckless in the manner in which it does its program. Secondly, the departments, they just come on the day and expect us to apply our minds on the day, and they go through concepts, and they go through all sorts of the acronyms that they are using, and I've said that in my previous thing. Don't use acronyms because those things are not helpful. Because at the end of the day, if it's a national nuclear regulation act, it must be that, so that you do not shortcut what is the work of Parliament here. I know it will be the excuse of time. It was because of time and all those things. But please, on concepts and many other issues that we have to comprehend in the committee. There must be a thorough explanation as to what then pertains to that particular acronym, what pertains to the time frame in terms of us as members of this committee to can comprehend and get around what the responses were. I'm not going to go through what AFSA have said, for instance. I'll go through in another meeting when they come and were thoroughly prepared, because you can't come on the day and expect me to then and expect us to can have made these things, these responses. Unless I like to speak for the sake of speaking, Chair, in the committee, because I should do it for malicious compliance. I'm always speaking in the committee. I must speak from an informed position here, and this is the responsibility of the department, period. Thank you very much.
Right, close the Honorable Mashaule.
Thank you very much, Chair. I had not raised my hand, but I want to try and see if we can't calm the situation after Honorable Gaza is raising genuine questions that we came to the meeting having not received any document from the department. And it may very well be that they received the comments late. I don't know what happened. Maybe it will suffice for us to say we are noting the document and probably get some time to look at the document before we go and deliberate ourselves. In any case, that is the intention of their responses to us, for us to apply our mind on how they see things and how the submitters have seen things, so that we collate the information and come with a better formulation of the bill. So I would really like to note the submission and say, let's go and apply our mind on it, and we will take it from there. Thank you very much.
Okay. Okay, let me do this. I think it is noted. My take, DG, is this, and I don't want you can explain. I thought Ntokozo was saying they've had to go over even the weekend with the presentation. Remember, the presentations or the oral submissions on the written submissions were done mainly on Thursday and Friday, which actually meant that it would have taken the weekend and yesterday probably to do this. But I think we are a fair committee, DG. You will bear with us. My request, especially for future purposes, we are doing these things because of the urgency or the need to make sure that we prioritize legislation. And in this case, we are sitting with two bills. And prioritizing the legislation, which means both of them must be prioritized. This committee has not been able to perform its actual work, especially in terms of oversight and ensuring that there is accountability for other activities that are taking place. It has been almost bottled on the legislation process, which we're not complaining. My appeal, when we make these proposals, it's more like proposals on the program. As a department, because we'll be the ones who are now to go through what NNR. Remember, we did all these presentations in almost simultaneous at the back of each other. Now, it actually means you have to go through all what the submissions were made on the NNR bill. You still have to go through all what what is it, the ERA bill is all about. In between, you did not have a day, to be honest, a working day, except the Monday. But honestly, there's nothing wrong that says to the department, before the committee or at the time when the committee finishes those submissions, we request, there's nothing wrong, we request, based on the fact that we are responding on 2 bills, can we request that we be given sufficient time to go through this exercise? And I will tell you what becomes the disadvantage. The disadvantage is that, for instance, I'm just making an example on the question that Honorable Milam is asking. The big question would be, have you done a benchmark? Have you looked into others? What is the common practice? And you didn't have, I can assure you may not have had that time. I feel at times you want to comply at all costs, and to an extent that you may be challenged that what you are presenting is a compliance exercise on what is normal for the committee to do. But in terms of substantial research, if I were to use the word in inverted commas, on the issues raised by these presenters in the committee, one would doubt that you would have gone through all these answers that you are giving, having done a thorough work. And I'm worried when it comes to the Electricity Regulation Act. So my request is that for in future, yes, the presentations that are being made here are just being made to guide the committee when it does its deliberation. The ultimate end of everything that is presented here lies with the committee. So my request is that in future, don't feel it obligatory to comply with a time frame that may not be fair in terms of making a substantive submission to the committee. So I take note of that exercise. But can I give you then to respond, including on that issue, because this is a response also on your apology, which is noted, but I don't want to sound like I'm speaking on your behalf. Can you respond on the 2 concerns that have been raised? In fact, 1 concern that has been raised, as well as the specific question that has been raised by Honorable Milam. My last issue is maybe it's linked also to Honorable Milam. In terms of the common rules on or procedures on human resource, who appoints and who disappoints, who removes a CEO, and who appoints a CEO. I'm raising this thing because it seems in government there are 2 inconsistent processes. I'm sitting here, my assumption would be that the board appoints a CEO or recommends the appointment of a CEO. In the same way, the board, as a governor, as a governing structure of the institution, is responsible for the removal of the CEO, obviously in consultation with the executive authority. In your knowledge, which one is common and why, if I were to take this, why would you choose the minister to appoint the CEO and also to remove the CEO? I think if you can clarify those issues, because we don't want, I would fear a situation where the committee takes a decision that in future it may be contradictory to what we call common practice in government. Can I give it to you, DG?
2 Thank you, Chairperson. Chairperson, let me start with obviously the concern that's raised. I think from our side, we've noted it. We've also noted the counsel or the advice that you've given around us obviously coming back to the committee and in time if the timelines that we're working against will not work for us, and also obviously put the committee into a position that will not allow you to apply yourselves sufficiently. And once again, I think we've already apologized for the opinions, and we take the guidance from you in that in future we should communicate the pleasures upfront. With regard to the questions that were raised, on the maybe the one around the CEO, the example around the CEO and the appointment, the standard process is that obviously as the process, the selection process would normally be undertaken by the board, and a recommendation will then be made to the minister to appoint, and vice versa. In situations where there are issues and a member has to be removed, the same process is generally followed, even in the department. With regard to the question from Honorable Mailem around the practice in other regulators, I can at this point from my side only comment on what is standard practice with regulatory bodies in the DMRE. The process is as we have proposed it in the bill, but and I will defer to my colleague Didi Ngwabe. From my side, I haven't gone and looked at the alternative for benchmark with others to the extent of understanding the advantages and disadvantages of that arrangement. Didi Ngwabe, you can comment further if you want to.
Thank you, Honorable Chair. So this is one area that we looked at and we're still discussing even late yesterday with Mr. Zibi. We have done some benchmarking that Minister would make the recommendation for the consideration of cabinet. So maybe this is one area that we might want to reconsider the wording, just to add the recommendation to cabinet. And we are wanting to look into that as such, because as Honorable Mailem raises it, it might be raised as an issue around minister having unfettered discretion, and issues around unfettered discretion in legislation have been challenged before in other case law. One other thing which we are going to be studying between now and next week Friday is case law that the state law advisors are usually quotes to give us guidance when we draft clauses. So that there have been some case law that we would want to look at, even though maybe not specifically for this bill, but just as a point of reference. And then we will send a written submission to the committee on that in that regard. Thank you, Honorable Chair.
Those are our responses. I hand back to you. Thank you.
Yes, I see the what is this? The Can I then assume that DG, okay, when we deal with the explanation with the ERA bill, we'll take that in the submission that you have made into consideration, because I've also received some advice or counseling on the procedure. Can we then take it that the department with regards to this presentation and the next one, they're still going to be reinforced with the provincial public hearings, which will explain with the provincial public hearings, and still we may have to go through the same exercise. On that note, is there any other matter with regards to the NNR bill that I may not have attended to? If that is the case, it actually means, Ari, we will come back at yes, Honorable Malin.
No. Thank you very much, Chairperson. Greetings to yourself, members of the Portfolio Committee, and everybody on the call. Chair, I want to check, are we closed up to ask questions, given what Honorable Keza and Honorable Mahlaule have said, that we are going to go through the responses of the department? I'm not sure whether the coming of the department before the portfolio, should there be things that we do not understand, will still be allowed? Because remember, when we start with the deliberations, is the deliberations of the committee affording the legal team of Parliament and the state law advisor to advise us on how to craft the clauses. So maybe if there are things that we do not understand, are we going to get a chance for them to explain them to us before we proceed? Thank you very much, Chair.
Yes, Honorable Maninga. Remember, that's why I said we'll explain. They will still have to respond. For now, to the best of my knowledge, they are responding to the written submissions. They will still have to respond now to the outcome of the provincial public hearings. In this case, we will allow members, specifically on the NNR bill, to raise those issues that they so wish to raise with regards to the NNR bill. So it will be allowed. We will make that provision. Honorable members, having said so, I'm not sure. Let me get a procedural guidance. Do we now put this in abeyance, subject to what I've just stated? Sizoyivala le chat le besithe mayivalwe le chat ngoba kunabantu abasi-abusayo through this chat what. Point taken, Honorable Malinga. I take counseling. Honorable members, it actually means we are reconvening at 2 o'clock, isn't it?
That is correct, Mr. Chair.
Okay, honorable members, you have a break. It's 37 minutes past 11. Take all this break up until 2 o'clock. Let's reconvene. We will get now the presentation on the ERA bill. Thank you very much. The meeting is adjourned.
Thank you.